Today we'll start talking about the relationship between oil and gas companies and the landowners whose land they operate on. So we'll start by discussing how they do the very first phase of the oil exploration process, where they take seismic imagery of the rocks underneath the earth to figure out where oil might be. And then we'll talk about some of the claims that you might have if an oil and gas company wrongfully operates on your land. So let's start by talking about exploration activities. And one of the most basic things you could use to measure the rocks underground is a gravimeter. That will measure the density of those subsurface rocks, and that will give you clues about what kind of rocks are in your property. And you may have a sense that certain formations are particularly likely to hold oil and gas. You can also have a magnetometer that predicts the subsurface structure. You can have conventional seismic imagery, which again predicts subsurface structure by shooting audio waves and seeing how they are reflected back from the surfaces beneath the earth. You can have 3D seismic, and I'll show you an example of that, which is used both during exploration and production phases, and it basically uses that seismic imagery to construct a 3D vision of across a property how those subsurface reservoirs look. And sometimes we talk about 4D seismic, which adds the dimension of time. So it takes that 3D picture of all those rocks underground. Sometimes we think of them as a series of pancakes stacked on top of each other. Some of them have oil in them. And if you look at that over time, that would be 4D seismic. So you might see how the density of those subsurface rocks changes over time if you're extracting the oil out of it and water is entering, or if you're extracting the natural gas. So here's how a conventional seismic system would work. You can see we have a truck here. So what this truck does is it sends out, sometimes we just call it a thumper truck. So it sends out sounds, and behind it, it has laid out sound detectors. And so basically what happens is those energy waves from those sounds hit hard layers of rock and are reflected up to the detectors. And based on those angles, we can tell how deep they have gone. And that can give us a sense of where oil reservoirs might be trapped underneath the ground. Here is what an actual thumper truck would look like. And you can see this basic concept of a noise source and then some detection is used in a lot of different areas across the globe. You know, if you just have a regular, you can see this is sort of in a prairie near a mountain region. You might have something like this, but you can have very different kinds. Here is actually a recording truck. So this is a truck that sometimes you just lay out those recorders on the ground, but you might have a recording truck that collects all of those different sounds to figure out where the oil and gas is trapped in the ground. And here's what you might get at the end of the day, which is a 3D seismic image that looks over your entire two-dimensional property, and it says, okay, where are those different layers of rock located? Which of those do we believe have oil and gas trapped in them? As you can see, same concept is used across the globe in all sorts of different systems. So you might have, these thumper trucks here operating in, the kind of coldest circumstances in the Arctic. You can also have marine seismic. Basically the same idea, except for now we got a boat. So we have a boat. It lays out these detectors behind it. You can see these streamers. Again, it's going to be shooting out sound that's going to go through all the water and bounce off those subsurfaces. And based on the angle, they are able to determine what kind of rocks are in each different location. So this was back in the old days, you just do this with dynamite. It was very primitive. Nowadays, it's much more sophisticated, but it's still the same basic process. Shooting sound down, just like you might use an ultrasound image to image the body. Same thing here to image the subsurface. We're using sonic waves to get a sense of what kind of reservoirs are located underground. So when you have oil and gas that you are allowed to extract as an oil company under a lease, one of the first things you want to do is, if you don't already know where the oil is located because of neighboring properties or otherwise, you want to get seismic imagery of that. So let's talk about this Enron versus Worth case, which is from the appellate court in Oklahoma in 1997, and it's on page 119. So what you see here is Enron wants seismic, but the surface owner says you're not allowed in. Enron has got permission from some, but not all, of the mineral owners. Now, it's not uncommon that a surface owner is not happy when the oil and gas company shows up to do seismic. Why might that be? Well, one common reason is the surface owner has already sold all of his or her minerals. And so if they no longer have any interest in oil and gas production, you don't want oil and gas companies coming on your land for any reason. I mean, even worse, that they should find oil, and then you're going to have the disruption of an oil and gas well on your land. So if it was still your minerals, you might feel happy to have an oil and gas company come up and explore and look for oil, because then you're going to make money off of it. But if you've sold those mineral rights, or a substantial portion of those mineral rights, you might feel very differently. Court here says, once you have the mineral right, you get to explore, including using the surface for exploration. So Enron here has the right to go on and do this seismic exploration because it has permission from some of the mineral owners. Okay? Now you might wonder, well, why is it enough to have permission from one of the mineral owners? Shouldn't you have to get permission from all of them? Problem with that kind of rule is, remember, sometimes we said mineral ownership can get very fractionated over time. So you might have one person leaving the minerals under their farm to their 4 kids, and it leaving to their 4 kids, and pretty soon you have tiny fractions outstanding. And we wouldn't want one person who wasn't paying attention or couldn't be contacted to prevent everybody from exploring the property. So in Oklahoma, the rule is, look, as long as you have permission from a fractional mineral owner's interest owner, that's enough. Now that might sound like a big problem. What if it's just a tiny fractional owner? Should you really be allowed to explore the minerals? What we'll see in later classes is, in practice, it's not that big a problem, because as an oil company, you're not really going to want to get going on serious exploration and drilling unless you have most of the owners on board with your plan. In Louisiana, they actually provide for this by statute, and they say you need to have 80% of the mineral ownership on board before you do exploration. Let's talk about this Kennedy versus General Geophysics case, Texas Appeals Court, 1948. It's on page 124. So here, Kennedy seeks damages for vibrations trespass and for unlawful acquisition of seismic info. And basically what happens here is that those explorations were happening right up to the border of Kennedy's land. So if I drew a side section of the land, imagine that you have sound waves being shot out right on the border, and so they're bouncing in all directions. And Kennedy says, well, look, they're bouncing into my land as well, these sonic waves. Court says, look, the fact that it's vibrating your land, that's not a trespass. Unless you actually have some kind of damages that were caused, we're not going to do anything for you. And I did get one question, well, what if somehow it shook some soil loose or something that fell onto Kennedy's land? Again, probably in that case, you're looking, then maybe it's a trespass or maybe just a nuisance, but in any event, there is something actually physically going on to their land other than mere vibrations. Maybe you could have nominal damages, but again, you don't really have any damages that you can show that cause harm. There's also no evidence that there was wrongful acquisition of subsurface information from adjacent lands. Okay, so these sound waves are bouncing onto Kennedy's property, but they're not putting out detectors here on the Kennedy's property to get that information back. So there's no information coming back from the Kennedys to the seismic engineer, and so therefore, court says they haven't wrongfully taken any information on the oil and gas in your land. Now you might ask, well, what would be the big deal anyway with getting seismic information on my land? How could that really harm me? What we'll see is there are ways that it can, so that's important. Court says if the company had gotten direct information from Kennedy, it might have been different. Court also says if there was some kind of malice, which basically means some kind of intent to harm Kennedy, well then maybe there would have been a claim. But here it's just vibrations. They didn't get any information on Kennedy's land, and so it's not a trespass. Now this is one of the most interesting recent cases that we've had on this sort of question of subsurface uses versus surface uses, this lightning oil versus Anadarko case. It's only glad you have the most recent version of the textbook. It's a Texas Supreme Court case from 2017 on page 130 in your book. And the basic question is, two oil companies, Lightning Oil Company wants to stop Anadarko from drilling horizontal wells through its mineral estate to produce Anadarko's adjacent minerals. Okay, so Lightning has a mineral lease and Briscoe Ranch owned the severed surface estate above. So basically what we have here is we have some land here where it's actually Texas State Park land on one side here, and Anadarko owns the land, the mineral interest. On the other side, it's the Briscoe Ranch, and Lightning has the mineral lease. Now, Texas says, Anadarko, you get the minerals, you have a lease of the minerals, but you can't drill on our property. Well, what good is that? I've got the minerals, but I can't drill on your property. But that's actually not uncommon if you have particularly sensitive land. Nowadays, people say, look, you can lease my minerals, but I don't want you drilling on my property. And the reason it's now possible is because you can go to the neighbor's land and drill. In fact, it might be even more efficient to just drill in through the neighbor's land, turn sideways, and then drain that whole property. So you don't always need to drill on the land that you're going to produce. Now keep in mind, remember, Anadarko certainly can't have any fracturing that takes place on Lightning's property. But they're saying, look, we won't fracture till we get on our side of the line. So we'll fracture there and only produce from our side. We're just drilling through your side. We're not producing any of the oil on it. Okay, so who do they go to for permission? Do they go to Lightning or do they go to Briscoe Ranch? And the answer is they go to Briscoe Ranch. And the reason they do that is because although we sometimes say you own the surface, you own the subsurface, in reality, when you own the subsurface owner, when we say the subsurface owner, we really mean they own the minerals. And if you remember, we talked about this earlier, the surface owner, the owner of the rest of the land, also owns the whole subsurface except for the minerals. Now, normally, the main thing we want out of the subsurface is the minerals. So just to be, as a shorthand, we'll say, oh, the mineral owner owns the subsurface. But what this case makes clear is it's somewhat more complicated because Briscoe Ranch have the authority to allow Anadarko to drill through that subsurface so long as they don't damage Lightning's oil and gas reservoir. And so the court here goes through some ways of could Anadarko's well possibly harm Lightning's oil and gas reservoir? And basically what they say is, look, even if there's like a tiny bit of oil and gas that comes to the surface as you're drilling, this is not a trespass, okay? And we don't have any evidence that they've damaged an oil and gas reservoir. This is really still part of the non-minerals subsurface that belongs to Briscoe Ranch, and so Anadarko can go ahead and drill through it. Another case on exploration, Grinberg versus City of North Glen. Colorado, 1987, it's on page 142. What happened here, Grinberg had an unrecorded coal lease from the state owner. So if you can remember back to your property class, what does unrecorded mean? Well, it wasn't recorded where it was supposed to be so anybody could find it. Now, the city of North Glen gets permission from the surface owner, but never got permission from Grinberg, who held the coal lease to that land. And the city tested that acreage for a wastewater reservoir to see if that would be a good idea on that property. But that included assessing the tract for coal. And remember, Grinberg has the right to produce coal from that land because of his coal lease. Court here says you had to have permission from Grinberg. It wasn't enough just to get permission from the surface owner. So the question is, how does this testing really harm Grinberg? And we'll look at that. Basically, what the courts say is city needs permission from Grinberg because it could have found out that even though he didn't record his interest, it could have just gone to the state and asked the state for permission, and the state would have told them, look, Grinberg's got this coal lease. So what are the actual harms that come from testing somebody's land if they don't want it tested? Well, you can get some remedies. So one remedy you can get is the speculative value of the right damaged. So maybe if you find out coal isn't possible, it's not possible to produce coal there. Well, all of a sudden, Grinberg's lease is worth nothing. Previously, Grinberg might have been able to sell that lease. So it had some speculative value because maybe it had coal. If you find out it didn't have coal, that value goes away. We'll see cases like that. Another remedy you can get if somebody wrongfully tests or operates on your land is called a sumsit. And that's the value of the lease that they should have had to take that action. So if they start producing your property, they would have had to lease it from you. What kind of bonus would they have paid you for that? It can be slander of title. So if Grinberg had the opportunity to sell that land to somebody else, sell that lease to somebody else, and it went away, that's you can bring that kind of claim. Also, if somebody actually starts producing on your property, they can be liable for ejectment and conversion, which means they got to get off the land and they have to give you their oil well and the value of production. So sometimes you will have to let them take back the value of what they've given you if they gave you a great oil well, but only if that trespass was in good faith, and we'll talk about that. So, what are the damages that you get if somebody wrongfully comes on your property and drills a dry well? One is that loss of speculative value. So once they've come on your property and drilled the dry well, you may not be able to lease it anymore, and that means you won't be able to get the bonus that would come with a lease. So you get the difference between the value for leasing before and after the trespass, and we'll look at a case like that. A sumsit, again, that's what it would have cost them to lease the property from you. They just came on and drilled a dry well. You may say, well, they got no benefit from that, but they would have had to pay you to lease it, and so they should pay for that. That's what a sumsit is. Then slander of title, what's the difference between the offer that was lost because of slander and the property's value thereafter? So again, you had an opportunity to lease that and it was taken away because in the meantime, somebody came on, drilled a well on your land and it proved you didn't have any oil, then you have a claim for slander of title. So let's look at a case like this. Humble versus Kishi, Texas Appellate Court case, 1925, page 150. So here, Kishi owns a 3/4 mineral interest and Lang just owns a 1/4. There's a lease to Humble for 3-year primary term, but there's some delay in sending to Humble, and so there's a question about when the lease starts. And so thus when it ends, when that primary term ends. And as we'll describe in the leasing section, primary term is as long as the oil company gets to drill. If it doesn't drill by the end of the primary term, the lease goes goodbye. So with Lang's permission, but Kishi's protesting, Humble drills a dry hole, and it turns out the court says ultimately the lease had expired. So the Humble said, well, there's a delay in getting this lease. It should extend a little bit longer. Court says, no, the lease had expired, and Humble drills this dry hole. Well, what remedy does Kishi get? What happened, what Kishi is complaining about, the harm is, you might say you didn't have oil before, you don't have oil after, what's the problem? Well, the problem is that Kishi could have sold his minerals to someone for $1,000 an acre. But after Humble drills a dry well, all of a sudden its mineral value is 0 because everyone knows there's no oil and gas on this property. Court says Humble is liable for that loss of speculative value. There is one exception to this rule, which is the case of Wyoming. You look at the Martell case. In Wyoming, truth is a defense. So they say, look, Kishi, I'm sorry, there was no oil on your property before. All that Humble did is show there's no oil on your property. So truth is a defense. You can't rely on that speculative value it had before. But the normal rule in Texas and elsewhere is you can rely on that speculative value. And if it's harmed by somebody wrongfully drilling on your land, you are allowed to recover that money. Okay, what happens if somebody comes on your land and drills a wet well? So they actually hit oil and gas. Well, the typical remedy would be trespass and conversion. So you're going to get the well that they drilled plus all their equipment that they use to operate that well. And conversion means all the oil they've taken from you so far, now you get to recover that. Now, sometimes if it was a good faith trespass, you'll say, okay, sure, you should get all the oil, but after paying us for our expenses in drilling that well. So if it was a good faith mistake, I just made a mistake, I thought it was my land, turns out it wasn't. Often this happens because, as in this Humble versus Kishi case, there is just a mistake about when the lease ends, and so the oil company thought it was still validly operating. Then you're going to be able to set off your costs and say, okay, I recovered $1 million in oil, but I spent $500,000 on the well. Here's the other $500,000 in profits so far. However, if the oil company was operating in bad faith, and we'll see an example of bad faith, then the plaintiff is going to get the value of production at the wellhead. Good faith measure, as I said, more common, honest mistake. In that case, you're going to get the value of production in place, which basically means how much was the oil worth in the ground that they took, which means what's the value of the oil at the surface minus the cost of extracting it. All right, so I said we look at an example of bad faith. Here's this Kidd versus Hoggett case, Texas Appeals Court, 1959, page 157. Here the Hoggetts sue Kidd to remove the cloud of an expired but unreleased oil and gas lease from their record title. So they basically, Hoggets are suing Kidd saying, this lease expired a long time ago, and you are wrongfully pretending you still have the right to produce oil and gas on our property. What happened here is that Kidd completed a well and shut it in. As we'll describe in a lease case, if you hit a natural gas well, and that natural gas would be valuable if you have somebody to sell it to. But if it turns out there's no one to sell it to, most leases will allow you to shut it in, which means just save it for now, make a payment to the Hoggets here until there's a market for that natural gas. As soon as there's a market for that natural gas, you have to release it and start selling it, because the landowner wants you to start selling that natural gas because that's how they're going to get more money. These shut-in royalties are really a nominal fee. They're not much money. They're just kind of to compensate for the inconvenience of having to shut in well on your property. The landowner wants you to start selling that gas. The problem here is, so Kidd completed this natural gas well, shut it in, and paid shut-in royalties. So it's doing what it's supposed to do. Well, there's two problems. One is, this well was never really producing in paying quantities. And we'll see what that means and why that's important in future cases. But basically, this was never a profitable natural gas well. And in fact, you should note in the book that it says people wanted natural gas right in this area. So there was a company right in this area asking for natural gas. So you can't shut in a well if somebody is asking for natural gas next door, because the whole reason that you're supposed to be allowed to shut in the well is to wait for the natural gas market to be ready, to wait for somebody that wants to purchase it. And the Hoggets were able to show evidence that companies were desperate for natural gas, and Kidd never sold it to them. Well, what was the reason? Because it was never really producing more than just a tiny amount of natural gas. It was never producing in paying quantities. Kidd claimed that he still had this well on the property and still had the exclusive right to produce under the lease. And that lost the Hoggets an opportunity to lease it to someone else. They said, they wanted to say, basically, Kidd, you had your chance, you found nothing, you didn't get a well, let us lease it to somebody else who will give us a new bonus and can actually operate this and produce some oil and gas so we get a royalty. But that other company, when they saw that Kidd was still claiming that he had the exclusive right to produce under the lease, they backed out. So the court says Hoggets here had evidence of malice, which means a deliberate conduct without reasonable cause. So here there was not like it was an honest mistake by Kidd. We have this evidence that people in the area wanted natural gas, and Kidd shut it in and basically was just trying to hold on to this lease. Now you might ask, why would somebody try to hold on to a lease if all they have is this well producing a paltry amount of natural gas? Won't be profitable. Well, what you'll see here is that oil and gas companies, they always want to hold on to land. And the reason is, you never know when the next boom is going to come. And if you have the exclusive right to produce oil and gas on that property, it can be hugely beneficial. So we are seeing booms in West Texas oil production in places that had booms decades ago. And if you had an old lease where you kept operating one measly well on it, so you still have the exclusive right to produce oil and gas, that all of a sudden is very valuable, because now you're found a new reservoir where you're able to frack and produce a lot of oil and gas, and that's great. And as we'll see later in the class, those old leases are even more valuable to oil and gas companies because they usually offered very little compensation to landowners, and that meant the oil and gas company got to keep the vast majority of the oil and gas.